Welcome to Work This Way, a labor and employment podcast. I'm Tina Emerson, joined here with Jennie Cluverius, the Labor and Employment Practice Group Chair. Hey, Jennie.
Always good to be here, Tina.
Good to see you. Well, today we are joined by Maynard Nexsen attorney Bryan Baysinger, and he heads up the firm's intellectual property practice group. Bryan, thanks for being here.
Hey, thanks for having me.
Sure. Well, we have rapidly evolving technology and remote work arrangements, and employers are facing modern challenges when protecting their IP. Can you share the most common intellectual property concerns that employers are facing when employees are creating work-related content or inventions?
Yeah, that's a great question. Obviously, multifaceted. I think, given the current dynamic of remote work as well as the environment we're in, we're seeing a lot of fear. I would call it fear around loss of rights from folks that are working, from home offices or working from remote facilities, or just the general thought of employee turnover, which we're seeing some of that. And really that is contrasted against historical times where, perhaps lab manuals or engineering manuals were kept at the actual work facility. Now they're in the cloud or they're on a personal computer, and, distinguishing and having that, separation creates another hurdle for employees or employers to capture that type of IP and that, trade secret and business value.
Bryan, a lot of times, and this is one of the benefits of being an employment practice group in a general practice firm, we have the benefit of having people like you that we can go to. And when we have interdisciplinary type issues, which I think what we're talking about today definitely is, what steps would you recommend employers take to ensure that IP created by their employees, especially those workers who are remote or hybrid, but really any of their employees, still legally belongs to the business?
Yeah, I think we've talked about this before, Jennie, but really it's around clearly defining their role and the scope of their employment. Where that goes to is really the fact that if you're, say, let's just take plastics for an example, and you're working in plastics and doing maybe deck board production, and those folks then are innovating in that space. And the role is defined really as that, but they innovate tangentially to that. Well, if the role is really defined as just plastics for deck boards, you are really not capturing the other IP that may come out of that. So, clear definition of roles and scopes of employment. I think, that we like to tend to see that broader. The CIA agreement, right? The Confidential Information and Invention Assignment Agreement. That's a must-have for any modern company, especially if you have intellectual property or you're doing, novel business techniques. And that document should have everything defined as far as non-disclosure, as far as how to assign IP rights to the company, as far as practices that they need to take on to maintain confidentiality of that information. For instance, unfiled patents are trade secrets. So, all the company's trade secrets can point unless they no longer become trade secret, right, or published. So there's a lot around the document side that you can do. And then I think, one of the last things that, with hybrid workers or workers in place is really to incentivize IP creation. We've talked about this before with companies that, that are constantly innovating, and how do you reward your folks for something that's it's not part of the job description per se. They're maybe a manufacturing engineer, but how do you reward them to create additional value for the company? And that rewarding innovation piece is something that I kind of encourage companies to really think about systems that may incentivize those folks to add value back into the business.
Well, let's talk about generative AI for a minute. Everybody's talking about it. We might as well talk about it too. What new employee challenges does that present? There are AI tools in the workplace all the time. Employees are using them. What do employers need to be aware of as their employees are using these tools? And should they have an AI policy related to IP?
Yes, yeah, so absolutely. So, one of the biggest risks with AI, generative AI use is copyright infringement. So there are cases percolating right now that are working to sort out and define what it really is, but who is the ultimate owner of the content, right? So when you're generating content, it's generating from a corpus of pre-existing content from other artists or other individuals, right? And so you have this environment where if you just generate something and use it commercially, the question is, well, A, does the license of the, some particular software that you have even grant you the authority to do that? Secondly, is am I now susceptible to any of the artists that are in that corpus of information claiming I created a derivative work of their rights? So that's just on the copyright side. On the patent side, you risk the fact that it's no longer patentable because you exposed it to the public, right? You've gave it to a model that then integrates it back into its corpus of training data. So now you risk even losing patent rights. Both the Copyright Office and the Patent Office have made formal announcements to how they will handle particular AI content. That's for another day, perhaps a longer session. But there are certainly quite a few risks associated with generative AI tools, and I would certainly encourage a policy of sorts to kind of rein in that usage and at least consult with an IP attorney on what that end result is and how you're going to use it in the business.
So, Bryan, coming back around to the intersection of IP and employment, I want to ask you what you think employers should know about IP risks when employees use open source software or AI tools in conjunction with their work.
Yeah, another great but very difficult question to answer. So, open source obviously comes with numerous risks. You have to understand the licenses behind those open source materials. Now, there isn't a software on the planet today that doesn't impart some form of open source, right? Most of the open source is fine. We're not saying it's a complete foreclosure on it. But what you need to be aware of is open source software that contains copyleft language, which would then force the business to open up that end work product, right? The software that company is working to develop. If you incorporate copyleft, you then have to open that software up as open source. And so you lose the ability to monetize that software, which it's one of the highest things when we're going through due diligence, we're very aware of that fact, and we review all of those licenses. So one thing to be mindful of is to have education to at least the engineering team or the developers or the contracts that you're using to outsource development, the caution around open source software and to be cognizant of copyleft material.
Right now, what are the best practices that employers can take to protect their IP? For so many companies, it is really make or break for them. So it's a very important and proactive step they can take to keep their information safe.
Yeah, yeah, I think it's the same thing. We say this repetitively to clients. File early, file often, right? If you have assets that are worth protecting, file on those assets, right? And file often. So it's never going to be a silver bullet, especially with patents. It's never going to be one patent that's going to win the day. You tend to want to build what's called a thicket or a set of fences in around your property that helps keep competitors out. Not only does it help keep competitors out, but it also adds value to the company. So, there's kind of a multi-dynamic aspect to IP where it's not just protecting what you do, but it's also adding value to the company. I'd say as far as what are some other best practices, I mentioned it earlier. I think incentivizing folks to help develop IP. One of the things, IBM, let's say I worked for IBM for a while. they incentivize, they reward inventors by giving them, things that may be symbolic or maybe economic in nature, but it continues to drive employees to want to do things to help benefit the company, which then in turn benefits them, right? And so, I think there's a universe where a lot of even smaller organizations can think about, well, how are we going to incentivize innovation on our products and services? How are we going to convince our employees that this not only helps the business but helps them?
And Bryan, I actually want to ask you one final question about the intersection of kind of trade secrets and intellectual property. When you seek to protect your intellectual property through filings that are public, of course, that requires disclosure. And I imagine sometimes you and your clients wrestle with, whether or not to have public disclosure of something in order to protect it, or whether the better option is to try to keep something confidential in order to protect it. Can you talk a little bit about those considerations and just the things that you weigh with your clients when they're kind of struggling with a decision like that?
Yeah, that's a great point. Yeah, absolutely. So a lot of software we don't file on. We keep it trade secret. So, and I say that portion of software. So there are multiple facets to software. You have back-end software, which is software that's running on your server, right? The client server, the employer server. You have front-end software that the customer may see and get to interact with. And then you have APIs that may allow the front end to communicate to the back end to do certain tasks, et cetera. AI is a great example of areas that we may not seek to file a patent on. And what I say by AI is there's certain things within specific types of AI usage. So let's take neural networks, for instance. We don't really know how a lot of those weights move in neural networks, but we also do have certain things that we do, such as how we filter the data that goes into it, how we, train it on a particular subset of data, and the optimization piece that we do that together may form patentable subject matter, but could easily be worked around, right? There's a million different optimization algorithms and techniques. So in that instance, that secret sauce is something you may want to keep secret, right? Because its value as a patent is less than its value of not generally being known to others. And so it's certainly something we like to sit down with our clients and really kind of roll up our sleeves and understand, because that is a crucial piece of any portfolio is what, and also patents run out, right? They run out over a 20-year time period, whereas trade secrets last so long as they are secret, right? Now, traditionally, trade secrets lose value over time, but with that being said, that timeline may be for way longer than 20 years.
And I have a question for both of you, since I have two attorneys captive here. I know that you and work together a lot on these trade secret matters, and I wonder, in order to mitigate this type of risk, who is it that's bearing the burden of these kind of preemptive strikes before something bad happens? Is it the IT and technology team, or would you say it is the HR team that needs to inform and educate their employees? Or is it just a marriage of the two and they have to stay communicating?
Sure. Well, I'm happy to go first, Bryan, if you don't mind. I would say, kind of backing up even, a heavy burden falls on the company if you're litigating a trade secret case. And Bryan can speak to the IP side of that in particular. But Tina, you're right. The HR team, usually working in conjunction with IT, they bear the burden of effectively helping the company implement what we call reasonable measures in these cases to keep trade secrets a secret. And as Bryan said, trade secrets can remain a secret and they retain value, some of them for years and years. If you think about the classic formula for Coke, I mean, that's obviously been a trade secret that's retained its value over time. But if you fail to take reasonable measures to protect, say, that Coke recipe, if you are letting people have access to it who do not need to have access to it, if you're widely disseminating it, if you're letting people take that recipe and put it on a thumb drive and take it out of the workplace to work on something related to it at home, those are all things that are hugely problematic for an employer when they go to try to litigate a trade secrets case, because they will have to establish, again, that they took reasonable measures to protect these, whatever it is. We're talking about the recipe for Coke, to the fact finder, to a jury. And definitely in today's world, IT has a huge role in that. HR has an equally important role in that, including in onboarding, making sure that these documents, Bryan has talked about this intellectual property and confidentiality agreement, making sure those documents get signed, making sure that people are trained regularly so they understand what their obligations are in that respect. All of those things go to reasonable measures, even to the all the way to the termination of the employment relationship. Is HR actually going back and collecting the documents, reminding the employee of their obligations to return these things to the employer at the conclusion of employment? So if either IT or HR fails to do what they're supposed to do, there is a serious risk that the employer could be found by a jury or a judge to not have taken reasonable measures to protect their trade secrets, which destroys the trade secret nature.
Mm-hmm. Your thoughts on that, Bryan?
No, that's exactly right. Everything Jenny said is correct. I think, when you think about a typical trade secret case, the two biggest hurdles are, what is the trade secret, right? Because oftentimes that's a nebulous object. The second one is, what steps did you do to protect it and treat it as a trade secret? And as she mentioned, it's really, I think, an education perspective for us, and that's something we tend to offer. Is we don't only need to necessarily educate the C-suite, but the HR team and the IT team on practices that need to happen. Right, access control, huge things. Access control. You think it would be commonplace? We're not only talking about access control on electronic equipment, but buildings in general. I think. I've worked with sophisticated tech companies who have very great access control around their users. Oh, but you could just waltz into the, engineering room where all the computers are set up and everyone's at, and, there's really no access to the actual building is an issue, right? And same with manufacturing. We've had manufacturers who have trade secret formulas for resins who have no locks or doors on particular facilities that are using these resins to make products. And so, it is a very complicated process. I always say that, folks see the price of patents and they say, oh, well, trade secrets are cheaper. Well, I don't think that's necessarily true, because you have to treat the trade secret as the same investment as a patent, investing in that training and that education of your teams, as well as putting in place the proper means to secure that trade secret. So, yeah, I think everything Jenny said is correct. I just wanted to add that last note on it.
And that's a great point, Bryan. And we've actually had cases revolving in part around that physical access piece of it that Bryan mentioned, who had access to certain labs with various formulas or special chemistry, things that were going on back there. And if you don't restrict that, juries can be pretty hard on employers about that in determining or considering whether or not they have reasonable measures in place to protect their trade secrets.
Right. So it's a big team effort to protect your IP, whether it's HR, IT, and of course, great employment and IP counsel. So thank you both very much for your insights, Jenny and Bryan. Thanks for joining us. And we will see you next time on Work This Way. Thanks for watching.